Okay, we're going to be covering banking law and this area of negotiable instruments, which is again uh, based not only on common law contracts, but also um, on the whole area of the Uniform Commercial Code. Again, here's which is a massive body of law, as I discussed when we talked about sales law. Um, every state has adopted it to some degree. And we have Article 3, which is negotiable instruments. These are, uh, you know, things like orders to pay, where you have a check, you order your bank to pay somebody, and then promises to pay are loans. There's Article 4, which talks about bank deposits and collections, which I'll talk a little bit about here, but that's what you're looking at. All right, so let's get into it. I think it's important to understand the history of negotiable instruments. These are basically substitutes for cash. What goes back to medieval times, where merchants were wanted some way to some substitute for gold or silver, didn't want to get robbed, so they developed these checks and notes. It was called law merchant, and felt it was paper was safer than um, paper substitutes were safer than carrying gold and silver. So the UCC, as I said, was developed to allow for this and to so they create rules to facilitate commercial transactions. They don't cover all commercial transactions. They don't cover real estate contracts, for example, but they do cover sales law, which is sale of goods. We already talked about that. So with negotiable instruments, it's important to understand, common law contracts is still relevant. You have to, whether it's a check, an order to pay, check or draft, or a promise to pay, like a loan, you still need to be uh, aware of the requirements for a legitimate contract under common law, which is legality, capacity, the agreement itself, offer and acceptance, and consideration. So the two basic types of negotiable instruments are orders to pay, where you are the drawer, you deposited the money, the one who deposited money. The drawee is the financial institution, the bank, and who you designate on the check is called the payee. Important to identify who's who, because they have different obligations and liabilities. Promises to pay are simpler. These are loans, could be car loan, home loan, student loan, where there's only two parties. The maker, that's you if you're borrowing the money, and the payee, the lender, that will be specified in the loan. And to have a negotiable instrument, in addition to the four basic elements at common law, there are a few more, six more, to make it negotiable, to basically magically convert paper into a substitute for cash. So it's got to be in writing, signed by the party to be held responsible. You can look at a dollar bill. It's essentially a negotiable instrument. It's signed by the Treasury Secretary. Signed is be in writing, signed by the maker or drawee. Now the maker, that tells you it's a loan. You're the one that's the borrower. You're borrowing the money. You could have co-signers. Those are people who are going to guarantee or act as a security or surety for the promise. The other is the or the drawee. The drawee, yeah. So the it should be drawer, I guess. Signed by the maker or the draw. it should be, it shouldn't be draw ease. I'm going to change that right here. Yeah, The, an unconditional promise to pay, order to pay, can't be any weird conditions that are personal. For example, I loan you money if you promise to fix my roof. That's can be an enforceable contract, but it's not a um, negotiable instrument. Uh, the fixed amount of money. This is you could have interest, which doesn't affect that, but you can't have a situation where I agree to lend you credit up to a certain amount and we don't agree exactly how much you're going to use. These in the real property business are called um, home equity lines of credit or second mortgages, where a bank may lend you money based on the appreciated value of your property, your real property, but is up to a certain amount. So that's doesn't meet the requirement of a fixed amount of money. May be enforceable as a contract, but doesn't meet the requirement of a fixed amount of money. Payable on demand or a definite time. This is like a check you present, or a loan will specify when you got to pay it. Payable to order or bearer. Now, this is the idea that if you have a loan, for example, that's payable to the lender, uh, the lender may negotiate or transfer that loan via an endorsement, right, to someone else who will become a holder. So the lender is essentially the original holder. They can transfer by endorsement or negotiation to somebody else, and and make it payable to that person, natural or legal person. Or they can simply uh, leave the endorsement blank. They can have pay to the order of in a blank line and signed by the original lender, and that makes it a bearer instrument, which are more liquid and more valuable because you don't have to mess around with endorsements, and there's the whole chain of endorsements. Okay, so at common law, we talked about this idea of an assignment of a right. Now, the problem with the big thing at common law is that an assignment, the person who's making the assignment of the right to be paid, for example, is called the assignor, and the person in receipt of that is the assignee. And the deal there is the assignee steps in the shoes of the assignor and is subject to whatever defenses the borrower would have against the assignor. In the world of negotiable instruments, it's the right term is, assuming all these 6+ conditions are met, is holder. So the holder can transfer by assignment, but again, it's the holder steps in the shoes of whoever assigned the right, and they're subject to all the defenses the borrower would have. You have then transfer by negotiation. I mentioned this. Endorsements can be to a particular person or in blank, which makes it a bearer instrument. Again, a holder is akin to common law assignees, but you have this unusual situation where a holder can become what's called a holder in due course if they meet 3 requirements. And they take the instrument for value in good faith without notice it's defective. And if there's a holder in due course in the chain of custody, anybody after, whether they qualify based on these 3 conditions or not, is sheltered and will be considered a holder in due course. And why is that important? Because of a holder in due course are immune from what are called personal or limited defenses, which means if a borrower defaults, let's say there claims there's a breach of contract by the original lender, a holder in due course is not going to be subject to that. So that's a personal defense or others. There are also universal real defenses, which go to some of the issues we discussed with basic contract law, material breach. If the party is a minor, that kind of thing, insanity. So, as with sales law, there are warranties. If you sign a negotiable instrument, you have some risk, and because you warrant certain things. If you are negotiating a loan, you are warranting you have title to the loan and have the power to negotiate it. Another example is with signature. The maker on a loan is primarily liable. If you have co-signers, they are also liable. They can be primarily or secondary liable, depending if they are sureties or endorsers. So discharge, same thing at common law. We talked about this with respect to common law contracts, but talked about performance, failure of condition, breach. Like a condition could be your ability to get financing, breach, material agreement. We talked about all that, and obviously one way that a negotiable instrument can be discharged is statute of limitations. There's a time limit to enforce that from the date of the breach. Bankruptcy is a way to discharge loans. Not all of them, but your school loan, for example, is normally non-dischargeable. I'll talk a little bit about checks and Article 4, but so we're talking about cashier's checks. These are drawn by the bank on itself. The bank is both the drawer and the drawee, and it's purchased by the customer. In effect, the bank is assuming responsibility for paying the check plus making the check nearly the equivalent of cash. Certified checks are a check for which the drawee bank certifies in writing that it has set aside funds from the drawer's account to ensure payment of the check on presentation. On certification, the drawer and all prior endorsers are completely discharged from liability on the check. You have to be careful of these things. There are a lot of bogus cashiers and certified checks floating around. Sometimes you get them in the mail. Best not to trust. If you think it's legitimate, I'd go to your bank and talk to somebody in management that can tell you if it's good or bad. Okay, so I mentioned that banks have a interesting relationship to the depositor. They are, the idea here is that bank and the depositor have basically the bank customer relationship is based on a number of things. It's a creditor debtor relationship created, for instance, when a customer makes cash deposit into a checking account. The customer provides the deposit. The customer becomes the creditor. The bank is the debtor for the amount deposited. Agency relationship. This is basically common law with the customer and the bank, between the customer and the bank when the customer writes a check. In an agency relationship, when party, the bank, the agent, agrees to represent or act on the order of the principal, and that would be the customer. Finally, there's normally a contractual relationship when you have a bank account. All right. So that's all cool. Now, based on that relationship, uh, you have different things that can occur. Overdraft is where the borrower writes a check and doesn't have that much money in there. Banks can go ahead and provide that money, and they can charge you what's called overdraft fees. There are some limits on that. Post-dated sale checks, it's really up to the bank. A lot of times you see situations where a check is over 90 days old. Bank can still accept that if they want to. Stop payment orders, so that's where you cut a check and you want to stop payment on it. You have to have a good reason. You have to do it within a tight time frame. If you do it orally, it's got to be done within 14 days. In writing, best to do it in writing, and that lasts longer. And you have more time. You always want to check your bank statement. The danger with the stop payment order is that the check is not destroyed. It's still out there. So an unscrupulous person could try to run the check again, see if they can get it paid. Other issues, incompetence or death of the customer, depends on when the bank is aware of that, and it's still checks that are in the process or still can be processed for a certain period of time after the death. Forgers, drawers, normally that would amount to a disqualification, but it depends on who's negligent. Is it the borrower? Is it the drawer on a check? There's a whole collection process that's set forth in your book. The point there is that the check circulates through Federal Reserve banks, from the deposit bank to the payee bank, etc. And the time involved is often manipulated by bad actors to have you do stupid things uh, like the certified check scam, where you deposit the check, you do some stupid thing, and they ask you to wire money to them. Never do that. Never do that. All right, so you have electronic fund transfers. These are everything from ATM, point of sale, like what's called a Square or Block, I think, various systems that are tailored to various industries, direct deposit, online payment systems like PayPal, that kind of thing. Merging, online mobile banking, big deal. And then finally, AI and financial tech world. Like we can get into cryptocurrency, which you should know about, but I'm not going to cover it here. You can Google it and learn all about blockchain if you think that's a safe investment. All righty, that's the end of that.